Good evening. Welcome to the Thursday, April 12th Zoning Board of Appeals meeting at 7:05 p.m. Tonight we will be deliberating three cases, 82 North Street, 144 Seekonk Street, and 123 Seekonk Street in that order.
It's the other way around.
This meeting is being audio and video recorded per the open meeting laws of Massachusetts. Again, I'd like to thank Dave DeLuca for joining us this evening. Dave is our town council. As you're all aware, this is deliberations. So unless we have a specific question for an applicant, there will be no public comment. Mr. Kaliza, okay, so I'd like to, first we will discuss 82 North Street. So this is an open hearing, so could we please put together the finding of facts?
Well, let's, do you want to do a motion first?
Sure.
All right.
Motion would be in the affirmative.
The affirmative, okay. I would like to make a motion to uphold the,
No, you'd want to appeal.
excuse me, this is an appeal.
Right.
Okay, so deny the appeal.
You'd want to grant the appeal. Grant the appeal, then it would be discussed.
Okay, so we want to. Okay, I would like to move to grant the appeal of the Building Commissioner's Zoning Enforcement Officer's decision in accordance with Massachusetts General Law, Chapter 48, Section A, for the property addressed at 82 North Street, reference Assessors Map 21, Block 60, Lot 20, Block 60, Lot 29, in the R2 zoning district.
Do we have a second to the motion?
I'll second the motion.
Okay, discussion. Okay, 82 North Street is a non-conforming use lot. It used to be the family forest. As the finding of fact is that the owners of the family forest have not been in business for a period of 4 years. According to our bylaw F3B cessation, any non-agricultural, non-conforming use that has been discontinued for 2 years may not be renewed. What this would mean would be that the property would revert back to an R1 residential zoning, that all commercial items on the property, there's some bins there for donation clothing, any construction equipment, any commercial equipment would be removed from the site. So that's what we're looking at. And that is basically the fact of this case. The owners have asked us to continue their family legacy and allow them to continue the use. But again, our bylaw is very clear on the 2-year cessation. Any other comments? Okay, so we'll take a vote. Again, the appeal is to grant it, so a granting would be to grant Ms. Ruth Palumbo the appeal. A deny would be to uphold the building commissioner's finding and decision. Mike?
Yes, to grant.
No.
I know, I get mixed up. This
You
is
would,
the,
you would,
okay, no to grant.
no to grant.
No to grant.
Done.
No to grant. No to grant. No to grant.
And no to grant. Okay, that concludes the deliberations with regard to Ruth Palumbo and 82 North Street. The product will revert to an R1. I think this upholds Bob Bullock's decision with regard to how you have to handle the property. Okay. Our second hearing this evening will be 144 Seekonk Street.
Just a quick check. It says 123 for 715.
We don't have to follow the
Oh, okay.
time for deliberation.
Got you.
So the next one will be 144 Seekonk Street. 144 Seekonk Street was an appeal to the building commissioner's decision on a stop work order. The applicant had gone in and done what the board had thought was, what the building commissioner thought was extensive excavation and work on the property without proper permits or approvals. The board reviewed these, and I think we have a memorandum which I'd like for Attorney DeLuca to present to us this evening.
Yes, thank you, Mr. Chairman. I was fortunate enough to be here a week ago during the course of that hearing, which I understand has, many layers and complexities, and probably and a good deal of history. However, I was directed to the core issue here before your board is just as you had in a previous case. There was an order that was issued by our zoning enforcement officer to cease and desist certain activity that he was able to observe on property that he believed was in violation of the Norwood zoning bylaws. I'm sorry, the Norfolk zoning bylaws. And that order was, first of all, noteworthy to say, from what I understood, that from the day it was issued, that it was observed, which I guess, according to the calendar, was several months ago. Nevertheless, it was timely appealed and it was heard by your board over the course of several weeks or months, and you had the benefit of an expert to also provide you with testimony in the case. The applicant was represented by counsel, and myself here as counsel to the board and counsel to the building inspector, I took the opportunity to discuss the facts with counsel for the applicant, and as sometimes the case, there were things that we agreed on and there were things we did not agree on. But in any event, what we came together on was essentially a joint recommendation for your board's consideration, which would be the vehicle to dispose of or resolve the case. And that case is, again, the four corners of that case is the appeal that was made from the cease and desist from the alleged violation of Norfolk zoning bylaws. All of the other incidentals and layers that have to do with, a coming 40B project or any of the history you might have had with this applicant before or in the future is really not and should not be considered in the nature of this appeal. So with that in mind, counsel and I drafted a memorandum, which you have in front of you right now, that contains the essentials from the hearing and a recommended disposition, if you will, is sometimes the case with quasi-judicial hearings. There's an opportunity to present a recommendation, and it's simply a recommendation for your board's consideration. But it's a vehicle or an opportunity to resolve the case on that basis. So it's put before your board for discussion and determination, either for or against or to vary from it, whatever you think is correct in this case.
Thank you, Dave. And this would be a modification to the zoning enforcement order,
Yeah,
correct?
I think we can rightly say, I think it's section 13 of 40A, if I have that.
I think it's 14.
Yeah,
you said.
no, 14.
14.
Section 14 of Mass General Law, Chapter 40A, tells us what the authority or the power of the Zoning Board of Appeal is in the context of hearing these kinds of cases. And the verbiage is right there to read, but essentially it says you could vote to affirm the building inspector's decision, you could vote to overturn the building inspector's decision, or you could vote to make an order, decision, reverse, or affirm whole or in part, or modify an order or decision. So you have flexibility in customizing, if you will, something that you might find that works for your board other than to affirm or deny.
Thank you. Dave, would you also take a minute to explain? I think a lot of people, and I included, get confused with why can't we charge them? Why can't we just start hitting with fines? Could you please take a moment to explain that?
Again, and I'm not the judge of this case. Your board is the
Understand.
judge of this case. But the facts are that once there was an order that was issued, there was compliance. You know, and that's significant. Bob will tell you, you know, he has many cases where, you know, a place an order and the violations continue. That's a different kind of case than one where you actually get complaints, because remember, our zoning bylaws seek compliance. We're not in the business of making money, charging fines. We want compliance with the zoning bylaws. So if there's an order that's issued and there's timely compliance with it, that should satisfy the board insofar as at least the bylaws doing what they need to do. Now, you know, it's unacceptable, obviously, if there's repeated violations or in some way there's some defiance of the bylaws. You know, in that case, you know, there is a much stronger case for a fine or penalty, financial penalty in this case. And it's also noteworthy that in this case, there was the payment of costs for an expert provided to the board, which, you know, I think contributed greatly to the understanding of this case, at least in the course of the last hearing we had.
Thank you.
Yep.
Bob, do you have anything to add to that?
No, I mean, this is a decision by the board. You know, when I go out to these sites and I make a determination and then bring it forward, and, you know, if they appeal the decision, they appeal it to you guys, and, you know, I'm open to whatever you guys determine for the applicant, so.
Has everyone had a chance to read the memorandum? Okay. Again, I think what we've asked for is a modification. So could I get a motion to modify the zoning enforcement officer's order? Mike?
I'd like to make a motion to, excuse me, I'd like to make a motion to modify the building commissioner's order by, the Norfolk ZBA modifies the zoning enforcement officer's order by imposing no fine or penalty or requirement of replication for violation of the aforementioned bylaw. The applicant's adherence to the terms of the cease and desist order from August 17th, 2017 to date, and continuing, and in further consideration of the applicant's agreement to pay the costs of the town peer review expert in the amount not to exceed $4,250, which the applicant has already paid. The applicant waives any right of appeal of this finding and further agrees to provide reasonable, minimum 48 hours notice of any scope of work consistent with the provisions of Norfolk zoning bylaws, section D1A1, to be performed and allow photographs of such work by the Norfolk zoning enforcement officer or other appropriate authority. Notwithstanding this waiver, nothing herein shall limit the applicant's right to raise any defense or argument regarding this matter should any third party appeal the zoning board's disposition. This disposition shall not prejudice the applicant in any other proceedings before any board or commission or in the course of any hearing on an application, complaint, or appeal concerning property located at 144 Seekonk Street, Norfolk. It being noted that the finding is limited to the zoning enforcement officer's August 21st, 2017 stop work order only.
Thank you, Mike. Do I have a second?
Second.
Okay. Discussion?
Yeah. Although I am very respectful of Attorney DeLuca's negotiation of this tentative modification, you know, ignorance is no excuse for violating what is clearly our bylaws as it relates to clear cutting. I moved to this town in '85, and I remember sometime within the next couple of 2-3 years, somebody cut all the trees down on a property that's about 100 yards from where we sit, and everybody was all upset. Little was done. I can name many situations where people have done things that are clearly in violation of the bylaws, and they say, "I'm sorry, I didn't understand." This particular individual who has successfully brought forth to this board a major development in this town which was approved is well aware, or should be, and or his attorney should be well aware of what our bylaws are. It says limited clearing and excavation is permitted to obtain necessary survey and engineering data or other activities required to secure necessary permits, according to Mr. Bullock's letter. But in his whatever this is, cease and desist order or whatever, the fact remains that we took a walkthrough on that property, and one of the pictures that I took that is part of this, was part of this hearing, all right, is an area where extensive gravel was removed and then was used to fill in an area of roadway, which has since been discussed at last week's open hearing, was possibly cutting off a channel of water, which I don't know anything about some of the conservation issues or non-issues relative to this property, but the fact remains is I saw in a significant amount of excavation. I have a picture of it here. It's part of the records which was submitted to Amy back, I don't know, 3, 4, or 5 months ago, whenever it was. And that soil was used to make a roadway. And then by our own peer review expert that we paid, who came in and said that the equipment that he would have used would have been able to go over the hills and dales of the land in order to accomplish what he would have needed to do the type of excavation and survey and engineering so that he could confirm that this site was acceptable. So having said all of that, I am not in agreement with this. I feel it continues to set forth to the town that we are not going to enforce when a developer decides he's going to act first and ask questions later.
You want to take a stab at that, or do you want me to?
You can take a stab.
I think there are two issues here, in my opinion, that one is beyond the purview of the board, and that's the wetlands issue. I think that's significant. I think there definitely was alteration there. I think he is in violation of our our wetlands bylaws, and the DEP and the Conservation Commission are looking into that. And so he's going to have to deal with them and that issue that is beyond the purview of this board and this particular cease and desist by the building commissioner. So I'm in total agreement with you. The wetlands issue, serious. I think there are major implications for what he did is wrong, in my personal opinion. That will be dealt with by DEP and Concom, again, beyond the purview of what we're looking at tonight, the cease and desist order. It did not address the wetlands issue. Did I capture that fairly accurately, Dave?
Yeah, I think that's true. It's very specifically intended for those boards to have the authority to judge the case on its merits in accordance with whatever rules or regulations that are applied to in those cases. So, yes.
You said there were two.
Well, the two is the cease and desist, what we're dealing with is a specific bylaw, and the wetlands issue, which I think is a separate issue.
Should be separate, okay.
Is, in my opinion, is separate, and council.
Yeah.
And my comments really, the
Concern.
wetlands were ancillary, because that's Concom's.
Right.
It was just the building of a road that didn't exist, and then hearing our own peer reviewers say that equipment is designed and is capable of going through and doing all of this type of testing that would have been needed without having to build a road. So,
Mr. Chairman,
Go ahead.
I know that the motion was made relative to the 1, 2, and 3 paragraphs, but maybe it would be relevant to your members' concern, whereas the paragraph that follows the listing of the evidence begins with the sentence that the ZBA finds that there is sufficient evidence that the determination of the zoning enforcement officer of violation D1A1 dated August 21st, 2017 should be affirmed in accordance with the provisions of 48 section 8 and 14. Now, that could be the substance of your vote. Now, but it's also clear from what we negotiated is that they have denied and will want to continue to deny that. I mean, and that's an unfortunate reality in most of these kinds of hearings. You accept evidence, you have the right to make a finding, they've denied it, but, you know, the disposition just kind of moves on from that. But just whether it's relevant or not to the members' comments, there is that determination.
Yes. I mean, the board did find that he was in violation. Obviously, Attorney Ducal has expressed, and it's hard to swallow, that he did meet and do exactly what Bob Bullock asked him to do, stop work. So we can't just impose fines to make money. He stopped work. Is it wrong what he did? We've said that. He may not agree to it, but we said it's wrong. Plain and simple. And it stands as such to this board. If they agree to it, it stands as such to the building inspector. We could not modify this. It would go to court. Both sides would spend more money. And at the end of the day, we may end up back in the same spot. Because I think Attorney DeLuca will echo it, is the judges are not in the business of awarding fines and penalties to towns for this type of action. So we're gonna move forward, but at the same time, is what are we going to win? We may win nothing. This process has not ended for this project. It's got a long road ahead of us. We will certainly have, again, the DEP, the Concom certainly has their work cut out for them to resolve these issues that have been brought up with regard to the wetlands violations. And this board will also have to review a 40B for this project at some point forward. And again, we will hold his feet to the fire. I would ask that Bob Bullock also hold their feet to the fire. I think the photographs, we'd like to see something like what Patrick Garner did, you know, footage photographs of that property, and no leeway. And that's why we made sure it was 48 hours notice, so that you were notified and you had the right to get on there. And I think by doing that, we do the most we can do, the best bang for the buck on this property at this time. It will be back before this board.
Mr. Chairman, I think this adds some real teeth, Don, the 48-hour. He can't do anything. He can't go in there without notifying Bob, and which never was the case before. This adds some real teeth to our being able to go on, monitor, watch what he's doing. Bob's going to be there frequently, watching any activity. You know, one of the neighbors, I'm hoping, gets engaged here and is calling Bob every day, and when the neighbor sees equipment going up there. There is one neighbor on the left, I think the horse farm. I know Lorraine Sweeney will be watching very carefully, so I'm hoping the neighbors get engaged and they're calling Bob and telling him, hey, there's activity up here, get up here. Because they need to give him 48 hours notice that they're gonna be doing whatever work they're gonna be doing. Bob needs to know about it. So this has some real teeth, which we didn't have before.
The applicant and the attorneys are not happy with this. This was, I think, 4 iterations over the last 128 hours. They were not happy with this agreement. So, but again, it allows us, it ties their hands a little bit. Bob Bullock now has the right to tie up their hands and watch them. And that's what we want. That's what we want for the neighbors. Our job is to make sure that the zoning laws are enforced. Bob Bullock enforced them. Our job is to make sure they continue to be enforced. And I think that's what we're doing here. We're going to enforce those bylaws. And Bob is the person who has to do it, but it's going to happen now. And they've got to give us a notice, and we will have photographs so we don't run into the same problem we did before, them saying that, you know, all this was pre-existing. I think it's got a lot of bite to it, much more than we envisioned, but I think it's a good modification.
Plus, we've pulled DEP and Concom into this in a significant way. I think that's the bigger issue here. I think that's going to be significant for them.
I'm well aware of that.
Yeah, I think that's going to be huge.
But again, if someone wants to make a change, let us know. We can discuss it.
Mr. Chairman, I think another issue is that there was clearing of land right next to property lines, right next to abutters.
And the fact that you can't ignore there's a impending project, it removes the possibility of buffering along those property lines. And I guess, is there any way that there could be a restoration of those areas near abutters and where existing screening was removed? Could there be restoration within that area?
I'm thinking Bob might be able to, I think the problem is, I don't think he was right on the abutter's property. I don't think you found that. And I don't think we found that he did destruction to trees on abutting on the, at the property lines. So I think it would be, I think the problem would be is, how do we prove what was there that we're asking him to reclamate? And and as the 40B approaches, there will certainly be more work on the site. So does reclamation, what does it achieve? Do you plant a tree and then take it down? What tree was there? Was it a 2-inch caliper tree? Was it a 6-inch caliper tree? I don't have those answers because we don't have any photographic evidence of what was there. And none of the abutters, if I recall, have come to us and said that they've lost screening or lost trees on this property. Most of the abutters concerned have been due to the wetland issues, that they feel that the wetlands issues have been violated, and the issue of the open space that he made at the top of the hill. So I don't think we heard from any abutters that they're actually, their sight lines or their perimeter other properties have been damaged. So I don't think we could probably go for reclamation in that regard.
But there's trees, are there not trees behind where he's cleared? So it might be more difficult to tell now whether or not someone's maybe visually impacted in the future.
What, do you want to address that, Mr. Chairman? When I went out there, when I first got called, it was in relation to a property line. And they thought that they had actually crossed over their property line. But in reality, the property line was quite a bit further back from where they were actually doing the digging. So I don't believe that they took any trees down right along anybody's property line there. I mean, it is something that could be addressed during the 40B process as far as screening, when they're actually designing the development. But I don't think they actually took any trees that were screening the property from the neighbors that I spoke to. Actually in any area, honestly. Most of it was interior, so.
Could you estimate the closest he came with any of this clearing to any property line?
I would say probably 75 to 100 feet away.
Okay.
Yeah.
Right, thank you.
And part of the 40B we'll be looking at screening if this development is approved, obviously to the neighborhood.
Okay.
Yeah, he may have to add just because of the 40B. Okay, thank you.
We have a second, we have discussion. Do I have a,
I think we
I'd
may,
like to take a vote for the modification? Mike, yes to grant the modification?
yes, to grant the modification.
Don?
Yes to grant the modification.
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 And yes to grant the modification. Okay, that closes deliberations for 144 Seekonk Street. Bob, you have your work cut out for you on that one. Our next deliberation will be 123 Seekonk Street. At the last meeting, I passed out some finding of facts. I think we should probably, we don't have to use all these facts, but I think we should be reviewing the finding of facts for 123 Seekonk Street.
Future, I would suggest we call them not necessarily finding of facts, but until we agree as a board they're facts.
They were actually my finding of facts, so yes, they weren't the board's finding of facts. And that's why I passed them out at a public hearing, because if I passed them out individually, one might construe that they were my opinion of a finding of fact, and they are not. They're just my opinion of what I saw after reading the minutes and after watching the tape.
Duly noted.
So I think we have some, anybody want to start with some finding of facts?
You know, I'm going down the list.
Okay.
When we identify what's on the property, we have in there, I see here, we have the indoor arena, the barn, and the paddocks, right?
Correct.
Should we be identifying additional items on the property for this?
We can do that, right? Currently, there's an indoor arena, there's a
Right.
barn, and there's outside paddocks.
Right, but in addition,
Properties.
there's some homes or
Yeah.
other structures, do we have to
Correct.
for this, do we have to identify those?
There is, I think, three homes on the property. Just so people understand, we may be looking to Michael Brogan for technical information about his property. Is there 3 homes, Mr. Brogan?
Yes.
Okay, thank you. We have 3 homes on the property. The property is 6.76 acres.
Two properties, one property is 6.7, one property is 2 acres, and another property is an acre and a quarter.
What was the third?
Acre and a quarter.
1.25?
They all adjoin each other, right?
Hmm?
They all adjoin each other?
Yes,
Yeah,
sir.
okay.
Correct. Property is currently zoned 61B in the R3 district. There has been no complaints with regard to this property from the emergency management, fire, and police department.
Well, hold on a second. According to the letter Amy sent to our police chief, he said, and I quote, "Our communications personnel receive phone calls from his neighbors anytime there is a barrel race, event, or training session. The complaint is usually a noise complaint. We advise the complainant that we will log the complaint as a noise complaint." So, that was on March 29th.
Okay. So there are no emergency management complaints from our fire department, our police department noted noise complaints. Is that fair, Ms. Don?
Yes, it is.
Noise complaints. Which we have addressed, while we're on that, the town of Norfolk does have a bylaw, but we have found that the bylaw has not been violated with regard to noise for this property.
Now, just to clarify, are we talking about the bylaw that is only in effect from 10 o'clock till 7 o'clock in the morning, correct?
It's the only bylaw we have.
That's the only bylaw we have, okay.
Correct. The owner has 3 horses, boards 4 horses, and can board up to 12 horses. Is that correct, Ms. Brogan?
Correct.
There are private lessons given on the property by his partner, Paige. There are clinics on the property given by his partner, Paige, and other professionals. Michael's daughter and partner both participate in the cowboy mounted shooting. His partner lives at the property, part of the household. We've had many neighbors at the hearing giving their opinions. Many of them have spoken out with regard to noise and the events.
We also had 6 letters of opposition that were sent by abutters
Okay.
as a matter of record.
Oh. The owner received $2,400 in income from events that he hosted. This was 6 events. The owner did not receive any income from the organizational events, though his daughter and partner's entry fees were waived. The owner receives $28,000 in boarding fees, which does not include lessons or clinics given by his partners or other professionals. Is that correct, Mr. Brogan?
Correct.
There was a miniature horse show on the property, which was taken over from the Miller Street Barns due to lack of room. $400 was received by Mr. Brogan to host this. The town of Norfolk issued an entertainment license in 2017 for up to 22 events, including 2 floaters.
What does the 2 floaters mean? What does 2 floaters mean?
2 different types of events. One of them was the miniature horse show, something other than barrel racing and shooting.
22 is specified as
Right.
barrel, okay.
No alcohol is consumed during events or as part of the event, alcohol for sale. Mike's partner and boarders who have horses on the property, practice on the property 2 to 3 days a week. Is that correct, Mike?
Yes.
And practices are not considered events. Right.
Um,
Practices would not be considered events.
Correct. CMSA, which is a Cowboy Mounted Shooting Association, is the governing body for horseback riding and shooting. NBHA, the National Barrel Horse Association, is the governing body for barrel racing. Music is played when each of the riders are doing a shoot. No more than 60 seconds, that's the maximum. The ultimate goal of this cowboy mounted shooting is to become the world champion. Other events, including horseback riding dressage, are held in Norfolk on Miller Street, in Millis at Apple Knoll, in Dover and Medfield at the Hunt Club. In Acushnet, there's cow tagging. All these towns allow properties to hold events, clinics without entertainment licenses under the agricultural exemption.
Mr. Chairman, I'd just like to add to that. None of these events, per my phone calls, are shooting events. These are all dressage events. I don't know about cow tagging, but none of these are shooting events.
Okay.
Whether they're barrel events or not is irrelevant, I think.
Okay. Mr. Brogan told us that he spent approximately, and again, we sort of tried to work into this, 130 hours a month or 1,560 hours a year, doing farm chores, feeding, duties consistent with a barn. He spent 12 hours in preparation for the 12 events. And the events total 46 hours a season. 16 hours for shoots, that's 2 days at 8 hours. 16 hours for the large barrel racing, that's 2 8-hours. And 14 hours for 7 small barrel racing events.
Another statement of fact would be that a Norfolk Superior Court held that the property is not exempt from zoning agricultural uses under Massachusetts General Laws 40A by order on
I think the
January
court-
25th.
I don't think the court ordered the property's not exempt. That barrel racing and shooting is not exempt.
I'm sorry, I was reading Mr. Bullock's, the court ordered that any and all entertainment licenses issued by the town of Norfolk to Michael Brogan with respect to any and all barrel races and/or shooting events to be conducted at or on the Run and Gun Ranch are null and void, effective immediately. Mr. Brogan is free to reapply to the town for a new entertainment license that the town shall consider and act upon in due course in conformance with this decision and order and the town's zoning bylaws as appropriate. Dated January 25th, 2018.
Mr. Chairman, can you explain to me that the selectmen have given them permission, an entertainment license for 22 events plus 2 floaters? how do those 22 events break down? How many are barrel racing, and when I say barrel racing, and with the guns, and the guns being fired, how many events, do we know how many of those events are held each year?
I think we can ask Mr. Brogan if he can explain that to us.
Two events with guns. The rest of the events are barrel racing without guns.
So there are 2 events
Guns.
with guns and barrel racing combined?
Yeah.
No, it's cowboy mounted shooting. It's not barrel racing, it's.
The rest were all barrel racing.
Okay, so cowboy mounted shooting,
There's 2 of those.
2 of those.
The rest of them are, barrel racing.
Okay, so the cowboy mounted shooting, there are 2 events. Under the entertainment license you had with the selectmen, would you be allowed to do more shooting events?
No, we always kept it to 2.
But, I mean, if you wanted to increase it, could you have increased it?
I could have asked, yeah.
You could have asked.
Yeah.
Was their entertainment license explicit that you could only do 2 shooting events?
Yes. Yep. I had to tell them the dates of each event prior.
Sorry, Chris. Not following the rules, right?
There was 2 shoots, and the rest of them are barrel races.
So the rest of the 22, or the rest of the 20 are barrel races?
Correct, and then the 2 floaters, which one we use for the miniature horse show.
Okay, 20 barrel races. And what happens during the week? Are there events during the week?
No, sir, just on the weekend.
Just on the weekend? Was there testimony that there's training that goes on during the week?
There were clinics, correct?
Yes, we have practice during the week and an occasional clinic.
Clinics during the week and a practice. I think we said 2 practices a week and 2 to 3 practices a week and clinic.
Okay, so, so the only time any shooting is going on are for 2 events?
No, that's not correct.
You're right.
No,
Find out.
we practice there every week.
What's that?
We practice there every week.
Right, they're allowed to
We
practice.
shoot either
shooting
Tuesday or Thursday,
property.
depending on the weather.
Okay, so Tuesday and Thursday, there is shooting going on?
Yes, sir.
You also practice on the weekends?
Occasionally, if it's not a good weather day, Tuesday or Thursday, we may do it on the weekend.
The practicing on the weekend, though, is not 60 people. It's the people who are,
No, it's typically 4 or 5 people,
Right.
and
Okay.
it's for like an hour and a half.
not an event.
Is there anything we have to state for fact regarding shooting on properties? Anything we have to state as a fact? What
Yeah.
restrictions, if any?
Right.
Right.
There is, Mr. Brogan is allowed to shoot on his property 7 days a week, 24 hours a day. Is that the fact you're,
Well, we have to put it into the facts.
Yeah. that is a statement of fact? I think we have it out here. Yes. Owner has the right to shoot on property 24 hours a day, 7 days a week. As does any other resident in town, as long as they get permission and have the appropriate licenses and distances.
Setbacks.
Correct.
Yeah, setbacks.
Any more finding of facts? Discussion? Ron?
Why do we have to start with me? Let's start with,
Let's start with you.
let's start with Devin.
Want me to start, Devin?
Yeah, sure.
Okay.
You want me to start?
Oh, you could start,
Okay,
sure.
all right.
You're the vice chairman.
All right, all right. Here are some thoughts. I'm going to just throw them out there for everybody's consideration. I think there are 3 things that we need to look at, or else this gets overly complicated and goes beyond what we should be focused on. Number 1 is the activity in or outside the agricultural use requirements. Number 2 was the scope of these events excessive. The court felt that it was excessive. And number 3, what is the right number of events? And I put in number 3 because in the last, the court did issue a cease and desist order, but they also said Mr. Brogan is free to reapply to the town for new entertainment license, and that the town shall consider and act upon in due course in conformance with the decision and order and the town bylaws as appropriate. So he didn't close the door on Mr. Brogan from using the property. And my fear is that if we shut this down completely and he starts having private events there, having a few friends over who are doing shooting and barrel events, we lose all control over what's going on in that property. That's my biggest fear, that it becomes private, he, somehow figures out a way to have friends over. He owns the property. Hey, I'm gonna have a few friends over, and we're gonna do some barrel racing and shooting today. That's so that's what I'm envisioning could potentially happen here. And the decision did leave the door open for either an entertainment license. I don't necessarily agree with the entertainment license. I think this is a zoning issue. And the other issue that I think we have to look at is the activity in or outside the agricultural use. I think right now it is beyond incidental. I don't think it is incidental. I think I agree with the court that the scope of the use of the property right now is excessive. And it is outside. I think it's beyond incidental. And so, from my perspective, what I'm trying to do is balance what the court said and what Mr. Brogan has the right to do on his own property. He has the right to run these events as a private function, have a few friends over, and do we give up all of our control over this? So the direction I would go in, and if council can help me with this, is I think we need to confine and come up with the number of events that we think is appropriate, when they can be used, and then if Mr. Brogan wants to challenge that, what we decide is we think is appropriate for the use of this land. The neighbors don't want it. The neighbors are over here. They want to see absolutely nothing, and I can understand that. Over here is Mr. Brogan, private landowner, wants to use his land, and I think eventually will use it for private if we shut him down completely. So is there some common ground in the middle? And I think that common ground is to bring this back to where it is incidental to his main business. Right now, I think it exceeds his main business in the number of events that he's having. 22 plus 2 floaters, I think, is beyond incidental. So I'm not exactly sure what the right numbers would be, but I'm looking at cutting that down dramatically, maybe in half. So I'm opening it up to the board for discussion on whether you think that's a reasonable approach to take, number one, and if you think if it's a reasonable approach to take, what are the right number of events. The shooting does concern me, so we've got shooting going on for the 2 events plus during the week. Perhaps that can be restricted to once a week, and the 2 barrel racing and shooting events, so that's, bringing this back into what I think would be incidental to the main business. I think we have to look at the law, and the law is very explicit about what's incidental and what's not incidental. Right now, again, I think it's beyond incidental. We have to bring it back to an area where it is incidental to his main business. Those are my thoughts.
Is part of what we're going to do in terms of this, we have an appeal before us, right? Part of the decision we make tonight, do we also put conditions on the decision?
Wouldn't be conditions, we'd be modifying.
Modifying.
Be a modification? Correct.
Okay.
Did I?
There's, again, this is a very similar case to what you've had in the, earlier. We have a decision and a order from the zoning enforcement officer, in this case, however, interpreting a court decision as opposed to our zoning bylaws. He issued an order, and it's this board's, and there was an appeal from that order, and this board's entitled to hear the facts, as you have, and to make a determination of whether or not the zoning enforcement officer's order should be upheld, overturned, or modified. Now, clearly, no matter what you decide, there is still the risk of appeal from this board by an aggrieved party to the Superior Court for a review. That's, something that cannot be eliminated, but that, as we discussed a moment ago, the statute gives you the unique opportunity to affirm, deny, overturn, or modify.
Okay. I'm gonna take a little different tack from Mike. I think this property does meet the litmus test as an agricultural property, and I think that the cowboy-mounted shooting is part of that. The judge in his ruling cited Henry versus Board of Appeals of Dunstable. In that ruling, Henry wanted to clear cut and excavate a hill, gravel removal, similar to what we see at Abbeville. That was the new business he was taking on an agriculturally zoned property. It had nothing to do with selling the Christmas trees, but his thought was, I'm gonna do that, and then I'm gonna make it level, and then I'm gonna grow Christmas trees on them and let people cut them themselves. Dunstable said, clear cutting and mining of the land is not agricultural, and they denied it. If we apply that to Mr. Brogan's case, if Mr. Brogan put a sign out, gun shooting, $10, gun shooting lessons, it has nothing to do with his business of cowboy-mounted shooting. The court then cited Steed versus the Board of Appeals of Stowe. Steed wanted to open up a farm. Horse riding, horse raising, lessons. Town of Stowe fought it. The court ruled that this was agricultural. Absolutely. All those things are part of the agricultural exemption. Cowboy mounting shooting is the fastest growing horse sport event in this country. In 2018, there'll be over 500 events. It is the new dressage. It is the new jumper hunter. Did I ever hear about it before this Brogan case? Never. Why? Because it's in Florida. It's in Arkansas. It's in Arizona. It's in California. It's in Ohio. It hasn't hit the East Coast yet. But it is an agricultural event. The judge referred to the fact that it had to be incidental. He says the word incidental is incidental in the zoning bylaws. It means use must not be primary use of the property. One of our facts was Mr. Brogan spends 4% of his time on these events. 4% of his total time spent on his farm is doing this event. Say he lied to us and it's 10%. Say it's 100 hours instead of 46. Say it's 200 hours. It never even gets to the word, what I would call, incidental. The judge then says it must be attendant or competent with referring to incidental. Associated with is the definition of concomitant, and attendant is accompanying. Well, I don't think a horse can shoot a gun, and I don't think a guy can shoot a gun on a cowboy mounted riding without a horse. So I think the judge, he was on the right track. He said, while it is undisputed that Mr. Brogan's traditional horse breeding and riding lessons business are agricultural in nature, see Steig versus Board of Appeals of Stowe, the barrel racing and shooting events held at the ranch may be deemed agricultural only if they incident to or in conjunction with Mr. Brogan's permitted use. Incident is the use is one that is permitted as necessary, expected, or convenient. Well, I think if you're a cowboy mounted shooter, it certainly is necessary to do this. Just like a dressage rider practices, they have clinics and they have events. Same with hunter jumpers. Is it expected? Obviously. Is it convenient? Clearly. His partner is a champion, his daughter is participating. I think the judge lost that fact because what the judge heard was that there was drinking on the property, there was fires on the property, there was illegal parking on the property, there was Woodstock 2017 on the property. That's what he heard. Or maybe the judge didn't really understand a lot about horses or the horse business. And the definition in the definition of agriculture is the keeping of horses as a commercial enterprise. It doesn't go on to say what that commercial enterprise is. But I would say that what Run and Gun does, cowboy mounted shooting, is a horse commercial enterprise. The goal is to become world champion. The horses are bought and sold. There is over 2,000 horses for sale on the internet that are all geared towards cowboy mounted shooting. There are trainers, there are events. This is a new type of horse breeding, use that we've never seen on the East Coast. That being said, I think it does qualify under the agricultural exemption. But I think we have the neighbors have rights too. Our bylaw says it's exempt, but part of our job, because we're all residents of this town, is we represent all the people. Not just Mike Brogan. We have to be guided by our zoning bylaws. So I think Mike is on the exact right track. You know, we have to say you can have so many events. You can have so many clinics. These are your hours of operation. We can limit those things. Because in theory I think he has the right to do this. But we have to be concerned for the neighbors. We got to be concerned for the hours of operation. He has the right to shoot a gun on his property. And it happens to be he does it because he does cowboy mounted shooting. It may not be something we all want to get involved with, but it does have a right because it is part of the agricultural horse as a commercial enterprise exemption. And though none of the towns that we had as a finding of fact have shooting, every zoning enforcement officer, as soon as he heard horse, it's exempt, the agricultural exemption. So I think, from my standpoint, he meets the litmus test for an agricultural exemption, based on what I've cited. But I think what we can do is by limiting what Mr. Brogan is doing on the site, by trying to come up with a limited use for these, it will hopefully help the neighbors accept this. I think it's very difficult in neighborhoods. Somebody owns 6 acres, you own 1 acre. They're gonna have different rights than you. It's just the way it is. I live on Cleveland Street. I get to listen to the pounding of the new 40B. I get to listen to the Walpole Gun Club every Sunday morning and every Thursday night. I don't get upset because I understand I moved there. I'm in a rural area. I expect these noises. When the state bought a house across the street and put sex offenders in it, we didn't like it. But guess what? The state had the right to do it, and they did it, and you know what? I had to accept it. I accept the one nurse who drives out every morning at 4 o'clock without a muffler on his car. I accept it because it happens to be part of what happens. It's part of our rural nature. We move out here because we love agriculture. Everybody moves out here because they love the country. They want to be part of the country. They want the rural atmosphere. They don't want to hear the trains. They don't want to hear the garbage trucks. But then none of us want it in our backyard. It can't have it both ways. I think I'd like to see us limit Mr. Brogan to 12 events.
Mr. Chairman,
Oh,
excuse me.
yes.
Before we start.
Okay.
What's the, right now, how many months out of the year is this happening? Is this 12 months out of the year?
Mr. Brogan?
I'd say more like 9. We end before Christmas and we haven't started yet, so 8 or 9.
It's pretty much non-winter.
So starting in May?
We'll start,
No, it would be May through December?
Yeah, say April, by tax day, April 15th to
So 9 months.
Christmas.
I would start, you know, I'd condense that. I mean, if Mr. Brogan wants to appeal that decision, he's welcome to, but I'd start by figuring out what we want to condense that down to. 9 months of this activity is, again, I'm hung up on the incidental. 9 months is more than, that's 3/4 of the year. If it's incidental in terms of the length of time that this is going on, it has to be condensed. So I think 9 is the wrong number. I started with 3 months. What's the right number? 4 months? 5 months? June, July, August, September? I'm not sure, but again, incidental is a big part of what I'm thinking here. 9 months is beyond incidental, in my opinion. And so the length of the time of the year, the number of months that he's doing this is beyond incidental.
Do you have events for 9 months?
In October, from October until Christmas, we have 6 events. So we really stack them at the end of the season. And we might have 1 a month the rest of the time.
Are the shooting events in that October to December?
The shooting event is in June and in August, the same week every year.
June, July, August, September, October. 1, 2, 3, 4, 5 months. Versus 9.
What did you said June, July, August?
June, July, August, September, October. 5 months instead of 9 months.
Yeah, but he did say he goes beyond October, am I correct?
Oh, I know. Well, maybe it's July, August, September, October, November. I'm trying to get this so that it's not incidental. I think the 9 months is excessive.
I think the incidental is, his boarders and his partner can shoot every day on that property 12 months a year. So I think by trying to do a monthly, it's really the events that we're focusing on, because they can shoot 12 months a year. So you don't remove the shooting by limiting the time frame, because you can't stop that. So I think you can limit the number of events, but I think
But if
trying
it-
to tie it to months, I don't think you can do that, because he can shoot 12 months a year on his property, and he can ride and shoot on his property 12 months a year.
But he's not holding clinics. He wouldn't be holding clinics all the time.
No, he wouldn't be, we can,
the
but we can limit the clinics.
How do you define clinic versus
No, versus event.
excuse me. How do you define clinic versus, I'll call it a training or a class? In other words, his daughter is doing a one-on-one at 7 o'clock at night, training somebody, all right? That's what part of this exemption allows for breeders to do and trainers. So you're training somebody to run around a barrel, and you're training somebody also to shoot it's not a blank, whatever it is that you determine, to pop a balloon. That's all within the realm of something that's training. So I think it's important, a one-on-one or one-on-two training event, and then you have a clinic. A clinic to me is something that might be open till 6 or 8 or 10 people. And then you have events.
Correct.
Okay, so I just wanted to clarify that, Joe. I believe that as you look at the term incidental, that based on the interpretation of what the agricultural exemption provides for this type of property, that the training of horse-related activities is allowed anytime. My issue is not with the training. And that training, whether it be, his daughter or his significant other doing actual training, just like you would train anybody in dressage or anything else, and that training session, whether it runs from 7 to 8 or 5 to 7, that there's little that this board can do to stop that activity, because he has the right to do that. But to me, once you get beyond that individual type of thing that a breeder or trainer would do, and you call it an event or a clinic, that becomes something different.
Why do you say that? Dressages have clinics and dressages have events.
That they certainly may, okay?
You just said you can control that. They do that under the agriculture exemption.
I don't know that, okay?
Yeah, no, they do.
Mr. Chairman, the reason I was trying to skinny down the months is because if we're gonna have less events, if we're gonna, set some numbers on the number of events, we
Okay.
don't need as much time to do all those events. So, you see what I mean? If instead of 22 or 24, it's gonna be much less than that. He doesn't need the 9 months to do everything, I wouldn't think. That's where I was going with that.
Ms.
Mr. Rogan?
Now, we have barrel race in May, and we have barrel races in June. Specifically for the Cape traffic, they'll come up specifically for those months. I mean, if you wanted to say to have some type of limit to it, April, really it's April till second week in December. I mean, those last 6 events are really quick. They're an hour and a half apiece. So you're really talking about 4 major events in the season, period. Some of those small barrel races, I have more people visit the house than I do for these races.
That's why I was trying to go for events. Because I think if you limit it to 2 shooting events, 10 barrel racing, and 2 floaters, which is far less than what the town gave them. So 2 shooting events, which are in the summer, that's 16 hours, 10 barrel races all year. I think he said he has 2 major events, so that's 16 hours.
I thought you said 4 major events.
The two shoots, Mike, and 2 big barrel races.
2 big
There's-
barrel
there's
races.
4
The rest
big
are-
events.
The rest are small barrel races. And then the floaters are for something other than a shoot or a barrel race.
Like when we did the miniature horses.
They would not be a shooting event, a floater.
Never.
Okay.
Does that include the training sessions during the week?
We haven't got to that
No.
yet. These are events.
All right.
So then you get to lessons, which we cannot control because lessons are part of training. They fall under the agricultural exemption. So I guess clinics we could look at, which what are the, and let's go back to events. The total number of people allowed at events, I would say the total number of people, it isn't horses, it's total number of people. It's horses, riders, participants, Mr. Brogan, his partner, anybody there. I think something like 70, no more than 70 people on the property.
What's that equate to in terms of number of horses? 70 people is that 70 horses?
No.
How many horses?
What would
The biggest barrel race we have is 60 competitors. So
60?
60 competitors.
So that's 60 horses.
So no, they share. So maybe 50. Don't
50 horses?
Yeah, 50.
How many people normally in a clinic?
A clinic would be like 10 people, 10 people that we've taken through lessons, and a clinic is just a miniature show. Like, we just try and walk them through it.
And how many clinics were you looking for?
How about 6?
6
6.
from April to December.
Yeah, that's
So 1 a month.
correct.
So 6 clinics total, 2 shoots, 10 barrel races, and 2 non-shooting floaters. He can do his lessons because he's allowed. I don't think this falls underneath an entertainment permit. I think the zoning board, we control agricultural exemption. I think it falls under us. It's half of what the town permitted him last year. Thoughts?
My thought is just on, if you try and reduce the time frame and you condense how many events he may have or try to have back to back, and I think that would actually, I think, make the issue worse than having a longer period of time, less intensity for all his events.
So you like spreading it out over the 9 months?
I think spreading it out makes more sense.
Okay, I can buy that.
Yep.
I can buy that.
I agree with Devin as well. I think that the overall volume has just been excessive, and if you, even at the level that you're reducing it, if you take 3 months off of the total volume of time that you're working with, it's just gonna be, and it's gonna be right in the crux of when everybody's home over summer vacation and trying to sit outside and,
I agree.
you know, enjoy their property.
That's why I said, I think keeping it over the 9 months is better.
If
Yeah.
I'm hung up on the question of, we're focusing on the shooting events, but the total, those being what you view as the commercial enterprise associated with the agricultural exemption here, that it's a burgeoning business, but that's only 2 of the events that they're having annually. And I know that they're training and they're allowed to do that, and the clinics are important as well, but the overall volume of barrel racing, it seems like a lot of barrel racing for someone who's solely focused on the mounted shooting.
Or the 10-barrel racing, you feel is excessive? Do barrel racings make any noise?
Barrel races don't make any noise, and the reason that we have the barrel races is so they can see what the cowboy mounted shooting is. It is the next level from barrel racing. So it brings that clientele into our property.
Does the PA system get used in the barrel racing with the music?
No, not with the music, ma'am. It just like a baseball game, they announce the batter, who's up to bat, and who else is in, who's behind them. There's no music. The only 2 events that have the music are the shoots.
Okay, Don.
What about Joe?
I'm okay.
All right.
I guess I'd start with, we had the, let's see, this was the Norfolk Superior Court Justice's ruling, which we're told was based on information from one side, but without input from the other side. Correct?
Correct.
So I guess my first question in looking at this is, well, then I'd like to see all of the information that the Superior Court judge had in terms of making his ruling, because it appears that now we're making a ruling based on the information that was not provided to the Superior Court judge, but we don't have the information, or all of the information, that was provided to this judge.
Mr. Chairman, maybe I can
I
speak
knew
to
you'd
the,
be interjecting on this one.
I mean, I represented the town in the case.
And you're an attorney and I'm not.
Yeah,
so
no, that's okay. And let me just sort of brief you on just what it was, and that is that there was the series of hearings before the Board of Selectmen on the question of the issuance of entertainment licenses, and you know the matter of agricultural exemption did get discussed at those hearings. The Board of Selectmen ended up deciding what they decided on the number of licenses and the types of events. And just as there is the option here, there was an appeal that was taken by the abutters, and the court's obligation under those circumstances is to review the record. And the record that was contained and provided to the court was the record of what transpired before the Board of Selectmen. And, you know, those hearings were, frankly, they were not as detailed as what you've had here in terms of the amount of testimony. They're really focused in on the agricultural exemption and, you know, the activity of horses versus something else on the property. The Board of Selectmen, you know, were interested in, you know, the standards for the issuance of entertainment licenses, whether that was noise, traffic, parking, and those kinds of things. It wasn't as detailed on the agricultural interest. But the court had the record, that is a copy of all of the minutes, a copy of all of the documents that were submitted to the Board of Selectmen, and the parties filed cross motions, and the court decided based on that. Didn't have the benefit of live testimony, that's for sure. It was just the record that was provided to the Board of Selectmen.
Okay. So I guess if that being the case, it comes back to what, when we originally looked at this, we said that we have here in effect, a court order that said that entertainment licenses issued to the town, okay, for these events are null and void, effective immediately. And our zoning enforcement officer was ordered, per the magistrate, to enforce that. But then he went on to say, Mr. Brogan is free to reapply to the town for new entertainment license, and the town shall consider. All right? So I guess I find it difficult to modify what the judge has issued in this order to begin with. All right? I would agree that some of what Mr. Brogan does is certainly not incidental, but I also understand Mr. Brogan's rights as it relates to owning over 5 acres of land, having a agricultural exemption, and I certainly understand that the raising, breeding, training of horses falls into the category of the agricultural exemption. So I have difficulty, in effect, sitting here and saying versus modify. As I look at it, I have difficulty sitting here and saying I'm going to write new zoning regulations, which this board is not allowed to do.
We're not gonna write new zoning regulations, so.
Let me finish, okay? I have difficulty trying to internalize and understand how we're going to maybe, I'm going to say, write zoning regulations, because our job is to adjudicate or to interpret things that, in effect, would allow us to somewhat sidestep what regulations are because of certain circumstances. And you know, when we go and we do variances, we pull out the pink sheet that Amy made for us, and we look at the 4 circumstances under which, by state guidance, we can do a variance. And it has to fall in one of those 4. And as I look at this, I'm saying, we have a court order. Yes, Mr. Brogan should take this immediately back to the town. Then, you know, maybe it's in the town's responsibility to say back to the zoning board, come up with some bylaw changes, let's vote on them at town meeting, that we will then be able to enforce not only for Mr. Brogan, but for future people who decide they're going to do something similar. But that's where I'm sitting right now. I find it difficult to override Mr. Bullock's cease and desist order based on that information.
Okay. Other comments?
I think the judge kicked it back to us for us to make a decision. I think we should make a decision tonight.
Well, he kicked it back
Yeah.
to us to make a decision, in my mind, to uphold or deny, okay? And our attorney is saying or modify, but he clearly said that he should kick it back to the town and as it relates to an entertainment license.
No,
Now,
the
I
judge
think.
said, the judge said the property is not exempt from zoning as agricultural uses under 40A, Section 3. That was his opinion. So the appeal is that it is agricultural or it is not agricultural, and that these events are allowed under that agricultural exemption, and/or do we want to modify the use of this property under the agricultural exemption? We have the right under this appeal, Section 14, to modify what he's allowed to do within the zoning law, state and local, allowing agricultural exemption. So that's what we would be doing. We are looking at what a judge said, and we have the right. That's why we are a Board of Appeals. We have a right to decide that no, it is exempt from the agricultural exemption, and therefore this is what we will do. We'll make it a little bit stronger. We have the right to actually modify the agricultural exemption to fit this particular property in order to protect the neighbors. I mean, that's what our job is. We're trying to protect the neighbors and follow the law. That's what we do every day when we look at variances.
Take the judge out. What if Bob issued this without the judge? Maybe if the neighbors went to Bob and said, we don't like what's going on here, and Bob said, I agree with you, and he ordered a cease and desist, which he could do. It would be before us in that instance as well. So take the court out, take the judge out. This issue could be before us without the judge being, or the courts being involved. I mean, Bob could have issued the cease and desist without the court being involved. So we'd be back here deliberating, deciding what to do anyways. And that's what we're doing tonight.
Mr. Chairman, if I could just comment,
Sure, Dave.
responding to something you said. That section 14 of chapter 40A allows the board not to modify zoning or agriculture or anything like that. The modification goes to the ability to modify the order
Right.
that was made by the
That's what I was
zoning enforcement.
referring to,
Okay,
right.
just to clarify that
Okay.
you could affirm, overturn, or modify the order based on evidence and findings that you make in the hearing. So if I may just continue, Mr. Kaliza's example is a good one. If Mr. Bullock had simply received information, made a brief inspection, made an order that gets appealed, comes before you, you have the benefit of testimony and evidence that he might not have had. And as a result of that, you might find that it's necessary to affirm or overturn or modify.
Which
based on-
we have done in the past.
Yeah, so,
However, he didn't come up with the order.
No,
He
you're right.
executed,
In
he
this-
executed it was specific, it's hereby ordered that, and he turned around and his cease and desist just regurgitates exactly what Judge Brian J. Davis, or I assume that's who it is,
Yeah.
issued on January 25th.
Well, this case, has that unique feature, that it was reviewed by a Superior Court judge, or at least the facts as were presented to the Board of Selectmen were reviewed by a Superior Court judge who came back with that decision, which I think Mr. Bullock was duty-bound to act on, based on, again, without any further investigation on his part, just following the order. Now, again, the case comes before you on appeal, and you have the benefit of all the testimony and analysis that, goes along with that.
If you think it's appropriate, Mr. Chairman, I'd like to recommend we take a 10-minute recess and write up a motion so we can vote.
Yep. Chris, could we take a 10-minute recess? Welcome back to the zoning board of appeal meeting. We will continue deliberations of the Run and Gun Ranch, the appeal of the building inspector's decision to cease and desist. I've tried to put together, based on what we've discussed, a modification to the cease and desist order. What it would include is 2 large barrel races, a limit of 70 people, 2 large shooting events, a limit of 70 people, 6 small barrel races, a limit of 60 people, 2 non-shooting floater events, a limit of 60 people. Clinics would be limited to 1 per month with a limit of 20 people. Events all being spread out between April and December. Saturday events would be from 8 a.m. to 6 p.m. or no later than 6 p.m. Sunday events would be from 9 a.m. to no later than 6 p.m. That no entertainment license would be required to perform the above events and/or clinics. Discussion.
Yeah, Chris, it was clear that the small events, the small barrel races, were not as substantial as the larger events. The 60 seems a little bit high when you talk about it being a small event compared to, is that a little bit too high, 60?
I think he said 10 to 12 people.
That's what I'm saying, it was
Small
substantial.
barrel races, Mr. Brogan.
30 at most.
Yeah, I think it should be a much smaller number.
So small barrel races, we could limit to 30,
I think that'd be much more appropriate.
okay?
Same thing with the non-shooting one, right? The floaters as well, right?
Hmm?
The floaters as well, right? Both the,
Don't know what it is.
Don't know
Oh,
what floater
okay.
is, yeah.
right. Well, I definitely agree that the 6 smaller events, that'd be my suggestion.
Excuse me, I just want to understand, we have people here, yet you said on the large barrel races, you could have as many as 60 horses. So I just want to make sure, that-
60 competitors, yes.
would those be horses?
Yeah, probably 50 horses, yes.
I was going to say, should we assume every horse has at least 1 or 2 people?
Every horse has 1 rider.
Well, obviously, yeah. But in other words, would 2 people come to,
Oh, you know what? I don't have control over that, but yeah, typically they come with a trainer or a parent, more a parent or grandparents. Yeah, I'm not gonna limit spectators, to view it.
so I think, Chris,
The selectmen limited the amount of people participating,
participants.
not in the venue.
Yeah, so Don brought up a good point. We're talking about participants, I think.
Yes.
Would constitute a,
Modification.
oh, okay.
Dave, there was a clarification, is that we talked about it last time, is an event. You know, we had this conversation, you know, are spectators considered part of the event?
Well,
That's what
it would seem that the, you know, we can define that in any number of ways, either as participants or overall number of people. They all sort of come together to constitute an event. I think your board is entitled to, if it chooses to modify the building inspector's order, to come up with a calculus, really, that makes sense in terms of meeting the objective, which I think this board is interested in doing, is making sure that this activity, events or otherwise, stays incidental to the principal use of the property as a place to breed, raise, train horses. I think that was the complaint of the court from the beginning, is that those activities or events began to overrun the agricultural interest and become much more of a commercial venture as opposed to staying within the agricultural interest. And I sense that you're going there, you're trying to get there to get it more in line. So whether you regulate it by overall number of people or by participants, find whatever way works for you.
Sounds like participants would work better.
Participants would work, yeah.
And it sounds like 60 instead of 70 would work based on Mr. Brogan's comments.
I agree. Okay. So 60 participants, 60 participants for shooting, for large barrel racing, 30 participants for the small barrel races, and 60 participants for the non-shooting floater events.
Could we ask him one more time, though, for the small events? What was the participant number he said earlier? He gave us a different participant number for the.
30.
No, what number did he give us earlier?
I think you said 30.
He said 30 for
Yeah. Did you
participants.
say 30 for the small,
That's the most, yeah.
the most?
Right.
Yeah.
Same thing with the floating events?
You don't know what the float is. Like last year, it was the miniature horse show, so I don't know what the float is until someone approaches me, like the
Wouldn't-
miniature horse show, and then their event was probably 50 people.
But I think we do want to put a limit to it.
Yes, we do. That's what
You
I'm
can put
saying.
it to 60. That's as many as we can get through there.
Right.
Mr. Chair, just for clarification, when we're saying participants, that means total number of people on the site?
No, that's the number of horse and rider.
Okay.
They are a participant. So that would be one horse, one rider would be one participant.
So we're not limiting the number of people from the public who can
No.
attend?
No.
Okay.
We would need to put in this, a participant is defined as, okay?
Participant is a horse and rider.
Mr. Brogan, what was, under your current entertainment license, what was the time that you were allowed?
Saturdays it was 8 to 6, and Sundays was 9 to 6. We
So I kept that the same.
So it was 10 to 6 on Sundays?
no, it was 9 to 6. You should have a copy of it.
Do we have a copy of that? Since I see this gentleman adamant that it was 10.
But if it's done at 6 o'clock, yeah, there's no more noise, dust. So it still leaves the traffic issue.
Dave, do you have any recollection of
said
that?
that.
I'll look for it.
Yeah, that's good of you.
I may have it here.
Provide the detail, that makes sense.
Maybe it might be somewhere here.
Ask that question again.
The selectmen are meeting downstairs.
Think they know?
At the discretion.
Yeah, we do that too.
Who does this?
Meeting
No,
downstairs.
who does the secretarial stuff? Does Marion do it, or
Sue.
oh, Sue does it? Dave, can we add that in? I mean, can we?
Oh, sure,
Yeah, I mean, we could put the
Yeah,
time to be determined based on the prior year's start time.
yeah. I mean,
Would that be-
Yeah, sure. I can, you can drop that in there.
And Chris, events have a time like this, let's say it's 6 PM, right? I mean, obviously, if the events are ending at 6 PM, there's still gonna be a lot of activity going on in terms of, horses going back into trailers, horses leaving the property. I mean, there's no way to really limit that, but I guess how's that scope?
Trailers,
I thought we heard during our finding of facts or during testimony that, and Mr. Brogan, if it's wrong, you can interject, is that 6 PM meant everybody off, done,
Okay.
back to residential neighborhood, is that correct?
no, 6 PM means the event is over. The PA system is off, and there's, quite a few of these people are friends of ours, and they'll stay and we'll cook burgers or do something. I mean, so trailers leave, literally, the girls get up, run their run, and get in their trailer and leave. So it's not like a mad dash to leave all at once. They'll run and then leave. They only make one run. That's it. They take the horse off, they run it once, they put it back on the trailer, and unless they know they won, they're leaving. So it's
So
not
the
like a mad dash
The
to get
events
out
are
of there.
done by 6 PM.
Yeah, we shut it down at 6. Last year we had
I don't think we
one-
can control him having burgers on his property. And I certainly don't think we want to have the police going over there at 6:02, trying to determine if it's an event or a
Right.
burger party.
I was just clarifying that, you know, when the event means those activities that they're doing, the barrel racing and all that, that could go up to 6 PM, the way we're writing this.
You know, so no later than 6 PM for the events.
Just have Bob go over every Saturday.
Right, no later than 6 PM for the events. 6 PM event,
I used
end
to
time.
like it done.
Well, that's, especially,
All right.
that sounds like what we wanna do.
Hmm?
It sounds like what we're doing here, yes.
If you want to, I mean, we can discuss it. You
Well,
want
or
earlier?
do we tighten it? I don't know. In terms of clearing, if we have a goal of, let's say, the majority of the participants being off the property, I don't know.
Could we cut that back to 5? Ask, I don't know. What impact does that have on Mr. Brogan?
Mr. Rogan?
Can't do it. Honest to God, we ran over 15 minutes on one event last year because somebody fell off a horse, and I had to come in front of the selectmen because we were 15 minutes over. I have to let these people run. They've sat there. And honestly, the 6 at the end start at 1 o'clock in the afternoon on Sundays, and they're done by 3. So, you know, I don't want to limit it to that, but that's the realization is the last 6 events are less than 2 hours.
Ready for a motion?
Want to make a motion?
Yeah, before we make a motion, Mr. Chairman, I think you need to determine, we need 4 out of 5 votes. Bob Luciano's not here tonight, so either Devin or Medora will be voting, and both of them have been here for all the meetings, so you have to determine who will be voting.
Devin will be voting, and we do need a supermajority, so we need 4 out of 5.
4 out of 5, right?
Correct.
Mr. Chairman, just on your question of hours, I do have a copy of the entertainment license that was issued in 2016. And that does indicate the hours of 10 a.m. to 6 p.m.
On Saturday or Sunday or both?
Well, these gave specific dates for barrel races, specific dates for shoots. I don't know what June 11th was.
Oh, okay.
You know, I don't know what May 1st or May 16th was. I don't have the 2017 license, although the hours on the application, it's indicated, what are the hours for each event? 8 to 6 was a request. So I don't have the 2017 license, though. I would suspect it's got to be the same as the 2016 in terms of the hours, I would guess. I think that's reasonable.
Which would be, it said Sundays 10 to 6? Or
10
does
to-
it give
10
it-
to 6.
All
events,
events,
10 to
were
6.
10 to 6.
On Saturday as well?
It just said all events.
All of it, sorry.
All events, yep.
Mr. Chair, just one last point of clarification. When we say, or when it said that all events to be spread out between April and December, does that need more clarification on what it means by spread out?
All events will be held between April and December. Is that all right? We had talked
Yeah.
about spreading it out over a 9-month period, so that's why I used that term, that phrase.
Just, I wasn't sure if that meant that there should be, you know,
Proportional?
one event every,
You
No,
want-
I think they have a schedule, it's just they'll be over a 9-month period.
okay.
It's
That was what
it's
I
a
was
window, it's
inferring.
allowable window.
If you wanted, if
allowable
you think
window.
it should be different, I think it has to be to what the events are, it isn't at his whim. It's whatever the cowboy mounted shooting events
I wanted to make
are.
sure I understood what was being said.
You know, I think it will be held over a 9-month period, from April to December, if that's okay?
And Chris, I can't recall, we went over these facts earlier.
Speak up.
We went over these facts earlier, right? The traffic control again, was there traffic control? Was there testimony that said there's traffic control for this?
He
Police
had-
details?
Yeah, I think in testimony, he said he had traffic control for one event. What was the reason, Mr. Brogan, for that?
The Pan Mass Challenge.
Pan Mass Challenge was happening that weekend.
All right, so at his discretion, he decided he needed a police detail for that.
Yes.
Okay.
But again, as we heard in testimony, though the police chief received noise complaints, the
Right.
police chief never received traffic complaints.
Okay.
And there was no accidents, according to the police chief. That was a specific question asked to him. Amy, correct? Was there any incidences to both police chief and the fire chief, correct?
I have a question. It's not so much as, from an enforcement perspective, but from a communication perspective. Does the way we're approaching this limit communication to Mr. Brogan? For example, if, I don't know how he was informed that there was a Pan Mass Challenge and this event was occurring the same time. I do know that the Pan Mass Challenge goes to both the town and the police chief, that they run through and say, here's what we're doing, when we're doing it. I don't know anything else above that, but there's a communication link to the police department, which the police department responds to the entertainment license as granted by the selectmen. So my question here is, they're gonna be that same communication link once we define this in terms of the parameters of the modification?
I think it's outside our purview. I don't think we can, he's running events. It's his responsibility to make sure he communicates with all other departments, that he's not violating any other bylaws or affecting any other operations or events during that day.
Then wouldn't it behoove us to put that in the modification, that we're naming 6, 7, 8, 9, 10, 11, 12, we're naming 12 events, that for these 12 events, that he would be required to send a note to the police department letting him know the date and time of the event to ensure that there is no, conflict or issue that needs to be addressed. Right.
Okay.
I don't know, does that make sense?
Yeah, and supporting what Don's saying is that we're saying in here, this modification, we're saying that no entertainment license will be required to perform the above events clinics. There may be a number of controls in the entertainment license that was granted that may need to be mentioned here in terms of, the controls.
Yeah, if I might, Mr. Chairman, I guess I'd like to give advice to your board that the comment relative to the entertainment licenses is probably beyond the scope of what it is that you're considering tonight, which is, the validity of Mr. Bullock's order. And the reason is this. The four corners of what you're looking at is really the agricultural interest and whether or not, the events that are planned or that he would be permitted would be within the scope of the agricultural interest or exceeding it. I think you're coming, into a zone where it likely will be and should be supported as incidental to the agricultural use of the property. The kinds of issues that your members brought up having to do with controls was exactly what it is the Board of Selectmen were aiming at, taking care of those kinds of logistical concerns. And I think if you read the Superior Court judgment in the case, the court gives the opportunity. It says, in fact, you bring these number of events, the scope of the events, the size of the events within the agricultural interest, then you may, go ahead and pursue the entertainment license. So I guess what I want to say is that's between Mr. Brogan and the Board of Selectmen. And therefore, I would advise that you strike that requirement from the order, if that's what this is, in order to allow that to happen, at a different day, a different time, with a different form. It'll be up to him to decide whether or not he chooses to pursue an entertainment license. It'll be up to the town and the Board of Selectmen to determine whether or not they feel it should be enforced.
I feel better there because, yeah.
Yeah, because I think that's really for the Board of Selectmen and not necessarily for the ZBA here.
My only pushback on that is, isn't this how we got into this problem? Because then the Board of Selectmen will say, no, not 6 small barrel races, 5 small barrel races, and it'll be 9:45 to 5:45. We open the door by allowing an entertainment license to get right back to why we're sitting here tonight. Because that order created the appeals, which created the Superior Court ruling, which brought it to the zoning board. So when you say, give the selectmen the right to do an entertainment license, you turn this 180 degrees back.
Listen, I'm not suggesting that it's mandated.
No, that's my
You know,
thought.
I
I know it's for my memories,
understand,
not for you.
Yeah.
That would be my reasoning. I think you put it right back to where we are tonight. If you do, we talked in testimony. Who receives entertainment licenses in this town? Anybody serving liquor. Does Holmes's Field get an entertainment license when they have Norfolk Day? No. Does Jane and Paul's get an entertainment license when they do hay rides? No. Does the Lions Club get an entertainment license when they do Santa Day? No. If Eagle Brook wants to host a bartending seminar, do they get an entertainment license? Yes. This town has never, and we heard in testimony, given an entertainment license for any event other than one serving alcohol. The selectmen created the problem which we're looking at this evening by forcing an entertainment license which didn't work. I don't want to get back. I don't want this board reviewing this again or any other type of event in this town to be reviewed this way again. It didn't work. Why would you want to go back there?
I mean, can we, I don't know how we can condition another board. I mean, that's basically what we're doing here, setting a condition for another board, telling them what they can and can't do. I don't know the answer, Mr. Chairman, but I'm guessing that that's out beyond our purview. I'm looking for guidance from council.
Yeah, I can only repeat what I said. Whether or not an entertainment license, so with all due respect, Mr. Chairman, whether or not an entertainment license is to be issued to a certain activity is really the Board of Selectmen. And, you know, I think that, you know, there's great respect for the ZBA's judgment relative to agriculture and the action taken with respect to Mr. Bullock's order. But I think that whether or not an entertainment license is to be issued and what conditions is for the Board of Selectmen. It just is. I know that that it may be antithetical to the agricultural activity on the property, but then again, you know, this is one of the arguments that I made clear to the court. Understand that Section 3 of 40A, which is the agricultural exemption, does permit reasonable regulation. And it was, you know, with that in mind, that, you know, it makes sense. Just like, you know, the Barnstable County Fair, one of the biggest events down the Cape is an agricultural event. But, boy, they have police details there because they have to have a license in order to congregate like that. And the license was the ability to give the selectmen the opportunity to set those kinds of parameters. Now, I don't think there's the need for the selectmen to invade other aspects of it. That their entertainment license was really on that basis, to just control crowds. I think that what you've come up with here is a reasonable scheme that brings the number and scope of the activities within the agricultural interest. And I think if the Board of Selectmen is going to examine this for an entertainment license, that there'll be no need to get in that area. It's really just crowd control.
I don't think the Board of Selectmen wants to get involved in this case, quite honestly.
I think you're right about that.
I think they want to stay as far away from this as possible. I'd be shocked, and shame on them if they do want to issue an entertainment license. But I mean, that's just my
Okay,
opinion.
no, we can take it out. I have no problem with that. I understand.
Then, should we close that loop in terms of ensuring that there's a communication between Mr. Brogan and whether it be the town or the police department whenever he's having an event?
I made.
We don't know the date, but
Yeah, I made a note here, Don, Mr. Brogan will be required to notify both the Norfolk Police and Fire Departments of all of the weekend events
there, okay,
via email.
good, okay.
Yeah, I think that's a reasonable provision.
Take a stab at it?
Okay, so Devon's gonna be voting, okay, based on testimony and evidence heard, the board motions that the cease and desist order of the building inspector be modified to allow the following. 2 large barrel races, limit 60 participants. A participant is defined as a horse and a rider. 2 large shooting events, limit 60 participants. 6 small barrel races, limit 30 participants. 2 non-shooting floater events, limit 60 participants. Clinic limits to 1 per month. Number of participants, 20. All events to be held between the months of April and December. Event hours will be as follows. Saturday events, 10 a.m. to 6 p.m. Sunday events, 10 a.m. to 6 p.m. This would constitute a modification to the building inspector's cease and desist order, and Mr. Brogan will be required to notify both the Norfolk Police and Fire Departments of all his weekend events via email 48 hours prior to the event.
Second.
Any further discussion? Devin, we have a motion to modify, so it would be a yes to grant the modification or a no not to grant the modification.
Yes to grant modification.
Yes, the grant modification.
You can vote.
Oh, yes to grant modification.
Yes to grant modification.
Yes to grant modification.
And yes to grant modification. It's unanimous. The appeal is modified. Do I have a motion to close the April 12th, 2018 zoning board of appeals meeting at 9:15 p.m.?
I make a motion to
So
close.
moved.
Second?
Aye.
All those in favor?
Aye.
Aye.
Thank you very much.
I didn't even wait for you to say all those.